It says live on YouTube now.
Yeah, that's what we're going to do, is we're just going to do live on YouTube.
Okay.
Since the other court's not using it yet, then we can just go ahead and use that. Okay. So let me turn the record on. We are on the record now in cause number 323-113-06920. This is the May 27th, 2020 docket in the 323rd District Court. We're here on an adjudication in the matter of Slack. Present on behalf of the District Attorney's Office is Attorney Farmer. Present on behalf of the respondent is Mr. Graham, Attorney Graham, and the respondent, juvenile, and his mother are here on the Zoom screen as well. Mr. Slack, if you can please get in front of the computer screen, please. Switch over. I know it's going to be pretty tight in there, but and then also Mr. Slack's probation officer, Ms. Aguirre, is here as well. Okay. The juvenile was served with a summons in this matter, and the petition regarding that child engaged in delinquent conduct on February 27th, 2020. And that has, the return of that has been on file with the court since February 27th, 2020. And Mr. Slack, let me take your mute feature off. I need you to, you and your mom, please, to raise your right hands, please. Do you solemnly swear to tell the truth and nothing but the truth in this cause of action today, so help you God?
Yes.
Yes.
Okay, thank you. And Mr. Slack, what is your date of birth?
December the 3rd, 2005.
Okay, and where were you born?
Texas.
Okay, so you are a U.S. citizen? Is that yes?
Yes.
Okay, thank you. We are recording, so I need you to be clear. It won't, well, I can see your head not on the video. The reporter won't pick that up, okay?
Okay.
All right. So, let's see. Do you understand that the state of Texas is alleging that you have engaged in delinquent conduct, and that conduct that they've alleged is punishable by imprisonment or confinement in jail? Do you understand that?
Yes.
Okay.
Your Honor, before you continue, we should have a first amended petition.
Yeah, that's, oh, yes, that's what I'm reading from. And
Okay.
you know what, the first amended petition, thank you. So that first amended petition was served on May 27th, 2020, and it was filed with the court on May 27th, 2020, which was today. And on that note, I also do have the waiver of 2 days notice that the child is entitled to under 5307 under the Family Code. And so do you recognize this, Mr. Graham?
Yes, Your Honor.
And your client, Mr. Slack, you agreed to waive that 2 days from the filing of the petition?
He don't understand.
Okay, so Mr. Graham, do you want me to put you in a breakout room real quick with your client?
Yes, Your Honor.
Okay, let me do that. So Mr. Slack, you'll get a notification on the Zoom screen and you'll want to go into this breakout room. It's just going to be a private place for you and your attorney so he can explain that to you, okay?
Okay.
I'm setting it up right now. It should be ready shortly. There you go.
You're not supposed to. Oh, did we push anything?
Yeah, if it invites you to the breakout room, then you go into there and then you have to come back too. You have to click on it to come back as well. said by 10:15? He said by 10:15, so they have nothing else this morning, okay. Deputy Armstead, do you mind checking on the parents' laptop and seeing if they need any help getting back in, or like maybe ask Mr. Graham through there if they can, wrap it up? Good news is we only have a few more days of this Zoom hearing stuff. It was good to get us by, but it's getting old. Okay. They should be back with us shortly, I'm told. Oh, yes, thank you. Okay, so Mr. Graham, you'll have to unmute yourself again. And then, okay. All right, so we're back. And so, Mr. Slack, did your attorney have the chance to explain to you what that waiver of 2 days is?
Yes, ma'am.
Yes, and do you agree to that?
Yes, ma'am.
Okay, thank you. All right, so I think I left off letting you know what the possible punishment is, and that also you have a right against self-incrimination. So you have the right not to testify at all in this proceedings and not to say a word, just remain completely silent, okay? But by doing, by entering into the stipulation of evidence, you also give up that right, okay?
Okay.
Before we continue too, I do want to know that you agree to the waiver of the hearing before the district judge, okay? So you have a right to have Judge Kim, who is the elected official in this court, conduct your hearing, but your attorney has signed a waiver on your behalf, indicating that you are okay with having me conduct your hearing. Is that okay with you?
Yes, ma'am.
Okay, thank you. All right, and so you also have a right to a trial, but when you enter into the stipulation of evidence that you are giving up that right to a trial, okay?
Okay.
And at a trial, the state would have to bring witnesses in to testify against you, okay, to prove their case beyond a reasonable doubt. And you would have the opportunity to bring in witnesses to testify on your behalf. You would also have the right to cross-examine the state's witnesses or anybody who said anything against you. In other words, to face your accuser, okay, to confront, called your right to confrontation, okay? Do you understand that by entering into this agreement, you are giving that right up?
Yes.
Okay, and you're also waiving a right to a trial by jury because you have a right to a trial by jury where everything I just said to you is presented in front of a 12-person jury, and they would decide whether or not the facts alleged against you are true and you should be found to be delinquent. Do you understand that?
Yes.
Okay, you have a right to an attorney to represent you at that trial, okay, and you'd be giving up that right as well. You also still have a right to an attorney, and your attorney, as you know, Mr. Graham is here with you today, okay?
Okay.
And also, I have to let you know that I'm not required to accept this agreement that you've entered into with the state. And so once we go through everything and I read it all and I hear the testimony, I could decide that I don't like that deal and I'm not going to accept it. But if I do that, then I have to let you know that before I make that decision, okay?
Okay.
All right. Or before I can adjudicate you or not. So, and that way you can have the opportunity to change your mind. So, Mr. Graham, is there any reason why your client wouldn't understand the proceedings today and what he's facing?
No, Your Honor.
Okay, and is he fit to proceed?
He is.
Okay. So, Mr. Slack, you find your first amended petition here. You're here today because the state of Texas alleges that you've committed an offense, okay? And this offense, if committed by an adult, would be considered a crime, okay? But because you're a juvenile and not an adult, it's considered a delinquent act. And so what the state has alleged in the first amended petition is paragraph 1. It says that you have engaged in delinquent conduct and that you violated the law of this state, punishable by imprisonment or confinement in jail, and that is section 31.03 of the Texas Penal Code on or about the 8th day of January 2020. In the county of Tarrant, state of Texas, that you did unlawfully appropriate by acquiring or otherwise exercising control over property, namely a golf cart, of the value of $2,500 or more, but less than $30,000, with the intent to deprive the owner, Joseph Davis, of the property. It also alleges in paragraph 2.
Your Honor, if I may interrupt, where the state is waiving paragraph 2.
Okay, yes, okay, so I want him, but I still like to read them to them so that they understand that they're getting a benefit of a bargain.
That's fine, thank you.
Thank you, okay. And so they've also alleged against you in paragraph 2 that you engaged in delinquent conduct, that you violated the law of the state of Texas, again, punishable by imprisonment or confinement in jail, specifically section 28.03 of the Texas Penal Code, on or about the 8th day of January 2020 in Tarrant County, Texas, that you did intentionally or knowingly damage or destroy tangible property, namely a gate, by driving a golf cart into the gate without the effective consent of Joseph Davis, the owner of the said property, and thereby did cause pecuniary loss of $750 or more, but less than $2,500 to the owner. In paragraph 3, alleges again that you engaged in delinquent conduct and that you violated a law of the state of Texas that's punishable again by imprisonment or confinement in jail, specifically 22.01 of the Texas Penal Code, on or about the 21st day of February 2020 in Tarrant County, Texas, that you did then and there intentionally, knowingly, or recklessly cause bodily injury to Divion McCarver by hitting Divion McCarver in the face with the hand of the respondent. Okay. All right. Do you understand what the state has charged you with?
Yes.
Okay. And are we waiving openings?
Yes, Your Honor.
Yes, Your Honor.
And then, Ms. Farmer, do you have any other evidence other than the evidence that you dropped off for the disposition portion?
No, Your Honor.
Okay, no exhibits, I meant, okay. Mr. Graham, any exhibits?
No, Your Honor.
Okay, and so I do have the stipulation of evidence here, Mr. Slack, indicating that you and your attorney in writing in an open court, your attorney signed this, but I'm going to, since your signature's not on it, I'm going to have read it to you and make sure that you agree with it. Okay. You're informed of and understand your right to present witnesses on your behalf and to confront those witnesses as we discussed. Remember me talking about that a few moments ago?
Yes.
And that you are voluntarily consenting to a stipulation of evidence in this case. And so you're waiving the appearance, confrontation, and cross-examination of those witnesses. And you also consent to the introduction of testimony by oral stipulation or by affidavits, written statements of witnesses, or other documentary evidence. Do you agree to that?
Yes.
Okay. And again, this is a waiver of trial by jury on here, that in open court, you understand your right to a jury trial and the possible consequences of waiving the right, but you are now waiving the right to a trial by jury. Is that what you agree to?
Yes.
Okay. All right, and I have your actual, and just Mr. Graham, just to be clear, you did receive the state's disclosure of documents, items, and information provided to you?
I did, Your Honor.
Okay. Okay, Mr. Slack, so I have the stipulation of evidence. It says that you agree. Mom, what is your name?
My name is Irma.
Okay, Irma Carter?
Yes.
Okay, and are you the grandparent of Mr. Slack?
Yes, I adopted him.
Okay. And oh, so you're his grandmother, but you adopted him, so you're his mom too.
Yes.
Okay, great. So you are the person who has custody and control over him, correct?
Yes.
And his date of birth is, like he said, December 3rd, 2005?
That's correct.
Okay, and you live on 3754 Sydney Street in Fort Worth?
Yes.
Okay, thank you, ma'am. And so, Mr. Slack, you agree to this stipulation and consent to the stipulation of evidence. So again, you are expressly waiving the appearance, confrontation, and cross-examination of witnesses, the right to a trial by jury, and further consent to the introduction of testimony by affidavits, written statements of evidence of witnesses, and other documentary evidence. You have waived your federal and state constitutional rights against self-incrimination after having been sworn under oath, as we did at the start of this hearing. You are confessing to the following facts, and you agree and stipulate that the facts are true and correct, okay? And that they are evidence in this case. And so what I will do is I will read them to you, and then I will ask you if it's true, okay? And I believe you already testified, but it's true that you were born on December 3rd, 2005, correct?
Yes, ma'am.
Okay. And then the second thing is on or about the 8th day of January of 2020 in Tarrant County, Texas, that you unlawfully appropriated by acquiring or otherwise exercising control over property, namely a golf cart, of the value of $2,500 or more, but less than $30,000, with the intent to deprive the owner, Joseph Davis, of the property. Is that true?
Yes.
Okay. And you know that such conduct is a state jail felony and violates a penal law of the state of Texas, punishable by confinement or confinement in jail or imprisonment. Do you understand that?
Yes, ma'am.
And it falls under section 31.03 of the Texas Penal Code, and it's defined as delinquent conduct in section 5103A of the Texas Family Code. And so, Ms. Farmer, did you say paragraph 3 is, it's only paragraph 1? Because I see paragraph 3 on here as well.
We're waiving paragraph 2, Your Honor.
Okay, waiving paragraph 2. Okay, thank you. Okay, and then you're also, paragraph 3, it is further presented and to the court that you in the county of Tarrant, state of Texas, on or about the 21st day of February of 2020, that you did then and there intentionally, knowingly, or recklessly cause bodily injury to Devion McCarver by hitting Devion McCarver in the face with your hand. Is that true?
Yes, ma'am.
Okay. And you know that such conduct is a Class A misdemeanor and violates the penal law of the state of Texas, punishable by imprisonment or confinement in jail. It falls under 22.01 of the Texas Penal Code and is delinquent conduct, again, under section 5103A of the Texas Family Code. Do you understand that?
Yes, ma'am.
Okay. And it says that you further agree and stipulate that you are in need of rehabilitation. Is that true?
Yes, ma'am.
Okay. Or that I'm sorry?
I said yes, ma'am.
Okay, I'm sorry. I thought you said yes, no. I'm sorry. Okay. And then it says you further agree to a disposition of 12 months of probation, to pay restitution of $437.50. And I believe that would be to Mr. Davis. Is that correct?
Yes, ma'am.
Okay. And the family partnership program to be completed and any additional orders of the court. And so is that your agreement?
Yes, ma'am.
Okay.
Are you sure you understand?
Yeah.
Okay.
Now you understand that, you know, this will resolve, this will, you know, this will end this part of your case. Okay. And then we'll move on to do your disposition and I'll decide, you know, if that's what I'm going to do is follow this deal. You understand that by entering into the stipulation, you give up your trial rights, but you're also giving up your right to appeal. Okay. If you have a trial, you have an automatic right to appeal whatever decision is made either by the judge or the jury. By entering into this stipulation of evidence, you do give up your right to appeal. Do you understand that?
Yes.
Okay. If you want to file an appeal, you would actually have to ask permission from the Court of Appeals. Okay?
Okay.
Okay. All right. And so with that, I do find that from the competent evidence of the, well, actually, is there anything else or do the attorneys waive closing?
Yes, Your Honor.
Okay.
Yes, waive closing.
All right. Thank you. So based on the competent evidence from this hearing, namely Mr. Slack's own testimony and admissions that the allegations in paragraph 1 and paragraph 3 are true, I do find that he has been delinquent as alleged in both paragraphs 1 and 3. And I will go ahead, approve and accept this. Okay, so we're back on the record now in cause number 323-113-06920. And this is our disposition hearing, Mr. Slack. Court will take judicial notice of the entire contents of the court's file, as well as the adjudication hearing that has been most recently conducted. Ms. Farmer, do you have an opening or any witnesses?
Your Honor, at this time, the state would like to offer Petitioner's Exhibit 1, which is a copy of the social history, and Petitioner's Exhibit 2, which is a copy of the victim court report. I believe both of these have been provided to defense counsel.
Any objection, Mr. Graham?
No objection, Your Honor.
Okay, then Petitioner's Exhibit number 1 and Exhibit number 2 are admitted for all purposes. Ms. Farmer, do you have any witnesses?
The state would call Selena Aguirre.
Okay, please raise your right hand. Do you solemnly swear to tell the truth and nothing but the truth in this cause of action today, so help you God?
Your Honor.
Okay, thank you. Go ahead, Ms. Farmer.
Thank you, Your Honor. Ms. Aguirre, how are you presently employed?
I'm a court intake officer with Tarrant County Juvenile Services.
And are you familiar with someone by the name of Santana Slack?
Yes, ma'am.
And how are you familiar with him?
I began supervising him and having contact with his grandmother monthly to check on his well-being.
And did you help draft the state's Petitioner's Exhibit 1, the social history?
Yes, ma'am.
And what is your recommendation for Mr. Slack?
The department's recommending that he successfully complete family partnership program.
I'll pass the witness, Your Honor.
Okay, any questions, Mr. Graham?
No, Your Honor.
Okay, any more witnesses, Ms. Farmer?
No, Your Honor. We would ask that the witness be excused in the state of arrest.
All right, thank you. This witness may virtually step down. I wasn't sure yesterday what language to use. We don't want her to leave the hearing, but you know, she can't really step down either. So, okay, any witnesses, Mr. Graham?
Yes, ma'am. I'd like to briefly call Ms. Carter.
Okay, all right, Ms. Carter, remember you have been previously sworn in at the adjudication hearing today, and I would just remind you that you are still under oath, okay?
Okay.
Go ahead, Mr. Graham.
Thank you, Your Honor. Ms. Carter, you and I spoke yesterday and we discussed what it would mean to put your son or grandson on probation for 12 months. Is that correct?
Yes.
Do you have any issues or concerns with you, your families, or anyone else's safety if he was released and maintained in your home on probation?
No.
Do you think it's in his best interest to resolve this matter by only being placed on probation and not being locked up somehow?
That's correct.
Is there anything else you would like to tell the court before the court decides to accept or reject this agreement of probation?
Well, I would just like to say that that the probation, you know, would be better for him, and that since the incident or whatever, he's been doing much better, and I have not had any problems out of him.
Thank you, Ms. Carter. I'll pass the witness, Your Honor.
Ms. Farmer,
No
any questions?
No questions from the state, Your Honor.
Okay, may this witness be virtually excused?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you.
And the defense has nothing
Virtually
else.
step down. No more witnesses, sir?
No, Your Honor. Defense
Okay.
rests.
All right. So I just need a few minutes to review the social history report and victim court report. As Ms. Farmer dropped them off before the hearing, I did not take a look at them. So I will look at them now. I have a question. Does Mr. Slack live at the apartment complex where the golf cart was found?
No.
No, okay. Okay, Mr. Slack, I hope that having to handle this has been enough to kind of set you straight and make you think twice about what could happen if you continue this kind of behavior. Has it helped you make a difference?
Yes, ma'am.
Okay, I know you've got a very good grandmother there, okay? She's out there working really hard, you know, in her career to support you and provide you with a safe home environment. Okay, so she does not need this kind of disrespect from you. Okay, that's one. Not only are you breaking the law, but you're also disrespecting her when you're out there doing this. Do you understand that?
Yes, ma'am.
And with that said, I know, like, I read a little about your history, and so I do have a huge heart for kids that have been through what you have. In the last year, I've touched most of the cases that Tarrant County has, okay, regarding kids that kind of came into the world in the way that you did. And so that makes me even more so want to see you succeed, okay?
Yes, ma'am.
So I do believe that the Family Partnership Program will be not only in your best interest, because you do need rehabilitation. I also believe it's in the community's best interest, okay, to make you complete something like that and to also make you complete a term of 12 months of probation. So I am going to go ahead and follow the agreement, okay?
Yes, ma'am.
And I think it's only fair as well that the restitution is to be paid half by you and half by the other respondent that was responsible for this, okay?
Okay.
I do want you to complete 8 hours of community service. And Ms. Aguirre, that can be done at any local nonprofit, okay? I'll let him and mom choose
Okay, thank you.
which place.
I have a question about the nonprofit.
Yes.
I have a nonprofit organization too. When I do, we just with the Tarrant County Food Bank, which he assisted. A couple of weeks ago, we fed 1,000 families.
Mm-hmm.
And then we also do away school supplies and clothes and Christmas gifts and clothes and food. Could he work that nonprofit or would he have to be with another one?
Well, I would like to have him be with another one. So that tells me you should have several contacts in the nonprofit world. And so I'm okay with him. I would like him to go kind of learn about some other ones. Okay. So if you did want to take him to the food bank, that'd be fine. But yeah, I'd like you to choose another one. Okay.
No, the food bank, that's where we got to receive the food from the food bank in order to give it away.
Right, I understand, but I know sometimes that the food bank is in need of volunteers also sometimes.
Right. Mm-hmm.
And so, but I'll let you, I'll trust your judgment, ma'am, to choose a local nonprofit other than yours for him to volunteer at, okay?
Okay.
It's 8 hours, that's not much, that's just one day of your time, so you know what it's like to put in a hard day's work, okay?
Yes, ma'am.
All right, because, you know, this poor guy, the person who was responsible for that golf cart, you know, he's now has a write-up in his employment history, okay, on that job. He's actually got in trouble from his employer for even allowing that to happen, you know? So you put him in a bad bind, you put his job in jeopardy, and he's got to probably has a family to feed, or at least he has to take care of his own bills and feed himself, right?
Yes.
So I need you to know what it's like to put in a hard day's work. So that's why I'm giving you 8 hours of that. All right, the restitution, 8 hours community service, 12 months probation, and the family partnership program. Okay, I need you to keep up that good behavior. Remember what the levels were in here when you came into Kimbo at first?
Yes, ma'am.
Okay, 1 outstanding.
Yes, ma'am.
Okay, you need to be 1 outstanding in the community and also at home with your mom, okay?
Okay.
All right, anything else?
No, Your Honor.
All
No.
right. All right, then that's the order of the court. Thank you.
Thank you, Judge.
Thank you, Your
Good luck,
Honor.
Mr. Slack.
Bye.
Thank you, Ms. Carter.
Do we leave? Do we click leave?
Yep, you can leave. I'm stop. I have to wait, give it a 20-second pause to end the YouTube feed is all. So I'll still be on here for a few seconds.
So do we wait in here or?
No, you can be excused. You can go and meet with your probation officer, and my bailiff will come help you. She's coming
Okay.
right now to guide you around. Okay?
Yes, ma'am.
Thank you.
I'll log off the computer.
Okay.